Today we are here with my fearless leader and troublemaker over here, Kerry Baker. Say hi, Kerry. Ursula
Hi.
here.
Hi. I cause no trouble. I'm a trouble-free zone.
Yeah, no, he's a trouble-free zone. I'm probably more of the trouble, but wanted to first say, for those of you that celebrated, I hope you had a wonderful Easter weekend and had some time to connect with the family and just enjoy the time. But other than that, are you ready, Kerry?
Let's do it.
Let's do it. All right. Channel of love, hope, and faith. I like that. If that was a place, I would go visit it. Okay, so this has got a couple of parts to it. 60% GERD rating cut to 10%. Appealed, state 60. CMP noted mistakes in previous DBQ where my esophageal cancer was directly linked to GERD wasn't considered even though they were aware. Should I have been rated 100% for the time the cancer was active? They never put me in for 100, only 60. Would this be a DTA, which is a duty to assist error? I requested higher level review. So yes, they should have considered it, but there's a couple of things without knowing the facts of the case and the timeline and when you had the cancer and when the claims were in. So this might be very fact specific. Kerry?
Yeah, I kind of echo Ursula there. I would add that if you know for certain that your cancer was active while the claim was pending, or within 6 months of the claim being pending, then yeah, you should appeal for a temporary 100% period for that time. But now, if the cancer was already in remission when you filed the claim, or at least when they made the effective date, not always the same thing, then you know that could be a little bit bigger issue for you. Of course, if they got the effective date wrong and it was in remission as of the effective date, but the effective date's wrong, and the effective date should be the date of the claim, and it was active then, well, then you've got an appeal there. I would add something though, the 60% for GERD, especially now that you've stopped them from reducing it, that's a decent rating for GERD. So I would try not to disturb that one, mainly so you don't get back in that reduction issue again. But I mean, bottom line is, if the cancer was active during the claim, then in that situation you want to appeal.
Yeah, and to add to that, you know, part of the reason you may have gotten that 60% is also for residuals of the cancer that are related to it. So just depending on what the record shows, if they do know that the esophageal cancer was caused by the GERD, and you would get a 0% rating because it's in remission, but you have a lot of side effects that are caused by, you know, medications and things like that, you can get those secondarily service connected. But like Kerry said, be very careful, especially if they've already tried to reduce. I hope that's helpful. All right, Dave Peter, currently rated 90% combined for all Agent Orange based, 60% for left ventricular hypertrophy, and 3.15 and 3 to 1 to 5 METs. Newest CMPU rates METs at 1 to 3. Diagnosed with ischemic heart disease and had 2 stents implanted and getting a 3rd stent in my left anterior descending artery on April 24th. Will the stents affect my rating for heart issues, and will ischemic heart disease be added to my current cardiac rating or be a new rating? So can you go back to the very first part of that? So the heart is one of those conditions where the heart disease, they base it on your METs level. So a 3 to 5 METs is what's going to actually put you at a certain level. But once you get down to the 1 to 3 METs, that's indicative of 100% rating for the heart. You won't get additional compensation for having the stents placed in your heart unless, you know, if your METs are still staying at 1 to 3. Something you may want, not cautious of, but if you get the stents placed in and then your heart becomes better and you go back to that, you know, 3 to 5 METs, you would be rated at the rate for the 3 to 5. So the 1 to 3 is indicative of the heart, and they will, Kerry, correct me if I'm wrong, they will be rated under the same condition. They are the same thing, essentially.
Yeah, you're right. The 1 to 3 should get you 100%, unless it, you know, somehow gets better. Yeah, and you won't get a separate, you won't get a separate rating for the ischemic heart disease. I mean, left ventricular hypertrophy normally is a symptom rating criteria. They don't normally code the condition under that particular diagnosis. Normally, it would be coded under something like coronary artery disease, which is ischemic heart disease, and the ventricular hypertrophy is a criteria that, for example, if you didn't have any symptoms whatsoever and your heart was good, except that it was enlarged some, that's hypertrophy. That would warrant a 30% rating by itself, even if everything else was good. But yours with the METs, that's why you got the 60%. The only thing that should change, if they do it right, is that 60 should go to 100 because of the lower METs. You know, might they bring you in for another exam once they do that? They could. But with the number of conditions stents and everything you had in your heart, I would expect and fight for a 100% rating from certainly the time you got that METs rating and going forward.
Yeah, and if that METs rating is also in your medical record and not just at the CMP, or if that METs rating isn't a new METs rating and you've had that, you can argue for that 100% further back as well. So, Alan, is an ACE exam by a CMP doctor good? Okay, so first, let me explain what an ACE exam is. When the CMP requests go out to the contract people, they can either say an in-person exam is absolutely necessary, but if based on the record and everything that you have, you feel as though you can do an exam and make a medical opinion based on this, you can use the ACE procedure, which is essentially just a record review. So it doesn't necessarily mean that an ACE exam is bad or good. It just means it's whether or not the doctor is going to review the record and make an opinion, or if they're going to call you in. There are times where an ACE exam is perfectly acceptable, and actually we ask for that because there's no reason for the veteran to go back in for an exam. He was just there 3 months ago. So no, I don't think it's good or bad either way. Yeah.
I agree with that.
Reek Omi, part 1. I am service-connected at 80% for cervical stenosis, degenerative disc disease, etc., right arm radiculopathy, left knee instability, bilateral ankle sprain, bilateral hip pain, deviated septum, and rhinitis. I was recently diagnosed with GAD, which is generalized anxiety disorder, and depression, prescribed Lexapro by my PCP. I was seen by a psychiatrist who wants to put me on something more powerful for my chronic pain. Can I submit a mental health claim for chronic pain secondary to my service-connected orthopedic conditions, even though I was recently diagnosed? Absolutely. You most certainly can. There are a lot of times where when people have very debilitating and painful orthopedic conditions, or even very serious medical conditions, or just a lot of medical conditions, mental health conditions can come from those. And so even if you had a pre-existing mental health condition that is then made worse by it, you can most certainly file for that mental health condition. We see it quite a lot. It doesn't, if you were recently diagnosed, definitely get your claim in and say, you know, this is secondary to my service-connected disabilities, and go from there. But yes, I would file for that. Cerebral 1. Kerry, I promise I'll let you answer some of these. I'm sorry, I'm just on a roll today.
You're doing great.
Part 1, submitted a claim for hearing loss June of 2011, denied March 2015. Appealed to the BVA, to the board, in June 2015. BVA awarded service connection, November 2023. BVA remanded to RO for hearing test scheduled for March 16th, 2024. I've been diagnosed with Meniere's syndrome with weekly episodes of vertigo. Question: if I'm service connected for hearing loss at 0%, could I be service connected for Meniere's? Yes, absolutely. So Meniere's is a lot more complicated than just the hearing loss and the tinnitus. It comes with things like the vertigo and ear pain that can lead to other things. And the way that you're rated for Meniere's is much different to just the hearing loss. So for example, when you get rated for the hearing loss, normally we see very low ratings because the VA, it's not even VA math, it's VA something where they essentially say, well, you can be deaf in this ear, but as long as you can hear out of this one, we're still going to rate you at 0%. So they kind of take both ears into consideration with your hearing. Whereas with the Meniere's, they go into a different rating schedule, and you can be rated much higher for that because they take in all of those symptoms that kind of fall into that. And so if you are only rated for the hearing loss, but you want to get the Meniere's service connected, you should definitely make sure that that happens, because it leads to a lot of other things, and it can be quite severe. And if you're falling because of your vertigo or you're unsteady, your gait is off, it's important to make sure that those things are service connected. Kerry, over to you.
I don't have anything extra. You're absolutely right.
Yeah, so definitely try to get that Meniere's. A lot of people don't even know what Meniere's is either, and so we've gone through files, and now I'm going off on a tangent, but we've gone through files where we've seen the people with, you know, the hearing loss, the tinnitus, the vertigo, all of that stuff, and, you know, kind of gone, look, even if it's not Meniere's, it's a Meniere's syndrome, and we should try to get that service connected as Meniere's. So keep that in mind if you're having those additional symptoms as well, that you can't get rated, and get rated a little higher than just the hearing loss. Jeff. I'm sorry, Jeff. I'm not going to try to say your last name because I will butcher it, but I've got Jeff here. Can presumptive gulf conditions, fibromyalgia, irritable bowel syndrome, chronic fatigue syndrome, psychosis, not otherwise specified, be denied because there's no diagnosis of it being undiagnosed? At the time of the denial, the CMP gave no diagnosis and did not say if symptoms were service-connected or not. Denied also on appeal because CMP and my doctor didn't list the other diagnoses were ruled out. So if everything was not ruled out, but they cannot say that they are presumptive. Also stated that I never complained in service, so they cannot say they are service-connected. So I'm actually, you have got the right person on this YouTube Live, and that right person is not me. The only thing that I do want to say is, and this is kind of just broadly, when it comes to a chronic fatigue syndrome, Typically, that does need to be diagnosed in order to get service connected for it. It could be a symptom, but all of the Gulf War vets that I've had that have this fatigue, without it being actually diagnosed, it's hard to kind of get service connected. But the rest of your question is Kerry's going to answer, and if you're a Gulf War vet, listen up.
All right, I'll do my best. So psychosis, let me hit that first. Psychosis is not a presumptive for Gulf War vets. Your question made it seem like it was. It is a presumptive condition if diagnosed within a year of active duty, but that's different than it being for Gulf War veterans. Now, yeah, typically if you're trying to claim irritable bowel syndrome, fibromyalgia, or chronic fatigue syndrome, they're going to want to see the diagnosis. All right, now those are not undiagnosed illnesses. Those are what's called medically unexplained chronic multi-symptom illnesses. Under the Gulf War regs, there's two types of illnesses that can be service connected, technically on a presumptive basis, and that's an undiagnosed illness or medically unexplained chronic multi-symptom illness, such as chronic fatigue syndrome, irritable bowel syndrome, and fibromyalgia. The irritable bowel syndrome is now technically a functional GI condition in the regulation, and the irritable bowel syndrome is one of the many functional GI conditions. So if you don't have those diagnoses, they're not going to service connect it, because then you don't have the presumptive condition. Now, that's the easy part. The hard part is I would need to see the records to probably answer anything more, because we see Gulf War claims go all kinds of directions. They're very complicated when it comes to at least VA's raters' mindsets. They get the deer in the headlights almost every time. You hit on something. There's a notion that, and it's an incorrect notion, even though they develop for it, that, in order to have fibromyalgia, for example, that they have to rule out every other possible thing. That if you have anything that could cause some kind of symptoms similar to fibromyalgia or the other two, that you can't have the fibromyalgia or the other two. I've seen it get as silly as somebody being diagnosed with depression or something like depression, anxiety maybe. And because of that, the examiner said, well, he can't have chronic fatigue syndrome or fibromyalgia because he's got depression. Well, that's just not true. In fact, one or both of those, the mental health symptoms, can be a component of the diagnosis. So you got to be real mindful of what the examiners are diagnosing, which may not always be the same thing as what you have in your file elsewhere. In other words, your treating doctors may diagnose you with fibromyalgia, and a CMP examiner may say you don't have fibromyalgia, and that's going to set you up probably for a denial, but it should be one that's winnable on appeal. So it's important you know the difference there on the undiagnosed illness and the multi-symptom illness. An example of the difference of the two, say you go in for fibromyalgia, that's what your claim is, and the examiner says, no, he doesn't have fibromyalgia, he's got arthralgia in the joints, right? Arthralgia is joint pain. That's it. Joint pain absent any finding as to the cause of the joint pain, like degenerative arthritis. Degenerative arthritis is not an undiagnosed illness, okay? And that would be a cause of joint pain. But if you don't have the arthritis, you have the joint pain anyway. They've got x-rays of the joints that are painful, and there's nothing there. And they say you don't have fibromyalgia, but you have arthralgia. Arthralgia is, I'm just using that as an example, is a form of undiagnosed illness because it's just joint pain. Neuralgia is just nerve pain. And so those types of things do make good claims for undiagnosed illnesses. And so it's a misnomer to think that every undiagnosed illness can't have a name to it. There are plenty that, I mean, without names, the doctors couldn't, they wouldn't know what to do. So understand those differences. Understand that you might have to appeal those if the examiners are saying you don't have these things. They put a little too much emphasis on ruling things out. There's case law that says you don't have to rule everything out in order to have one of these issues. So just keep that in mind. And also, there's a thought process that VA used to have for a long, long time, and a lot of people still have it in VA, that a medically unexplained chronic multi-symptom illness is only those three conditions. Right? That's not true. It could be a number of other conditions that are diagnosed as long as there's no etiology. In other words, the etiology of those conditions are unknown. And many of those conditions will mimic those three. There's tons of autoimmune diseases out there that, were in an individual veteran's case, because it has to be a case-by-case basis every time. The doctors may say, well, we don't know what's causing this autoimmune disease, and so that right there would make a good claim for multi-symptom illness, which is the autoimmune disease. What you want to look out for in those situations is the examiner saying, well, the etiology is the autoimmune disease. No, it's not. That's the cause of the problem. What's the etiology of the autoimmune disease? If the answer is unknown or inconclusive, then that's a path to service connection for a multi-symptom illness that's not one of those express three that are listed. So hopefully I answered the question there. I didn't go back and read the whole thing.
Yeah, and one of the things with these claims from Gulf War, if you are a Gulf War vet that's suffering from the multi-symptom illnesses and things like that, and if you're getting denied, it is a good idea to find an advocate. It is very, very complicated. It's very difficult. Even some advocates struggle with it, but it's well worth it to find someone who knows what they're talking about and knows how to argue these, because you essentially have to line it out and explain it very clearly. So, if you're having trouble, you may need some help with it.
In my opinion, most advocates struggle with it. So, yeah. No offense.
Jeff.
No offense to the advocates out there.
Hey, there is someone over here on the side. It's Scott DeMuth that's talking about an EPA Superfund, Nate. I want to talk about that real quick because I see this quite a bit in the cases that we file. So Scott is asking, he's saying, I was stationed at EPA Superfund. I was exposed to at least 7 different chemicals. I have type 2 diabetes, sleep apnea, and nodules on my kidneys and lungs. All are benign. I filed diabetes under the PACT Act. What's the advice? So I want to broadly say something about the EPA Superfund sites. There are a lot of them. There are a whole lot of Superfund sites, and a lot of these do also fall in places that were military bases. We get veterans that come in and say, well, I was at a Superfund site, and, we go through and we take a look, and yes, it's a Superfund site, but just because a base is a Superfund site does not mean that there was any human exposure or humans were not at risk for that exposure. That doesn't mean all Superfund sites, because there are some bases that are Superfund bases that we've been able to show that there has been an exposure. So, it's important to look at not just the fact that it's a Superfund site and that there were chemicals there. If they were just in the groundwater and there was no way for the chemicals to enter a person's body, either through inhalation, through the skin, through, other means, that's going to be a very difficult way to get service connection, just by saying I was in the EPA Superfund site. There is a website where you can go, I don't know it, but you can Google and find out whether there or not there was a human risk of any type of toxic exposure at these Superfund sites. And if not, you may need to try to find a different way to get the service connection. If for some reason you were at a base that had the Superfund sites that did have toxic human exposure, you are very likely, if it's not going to show up on a terror report, are going to need an occupational medicine doctor to say, yes, there were chemicals here and these chemicals cause these conditions. But just my overall thing was, just because it's an EPA Superfund site does not actually mean that you were exposed. So. All right, Alan, under legacy system, when a claim has been remanded back to the regional office, if it is denied by the regional office, can you then submit more evidence to the board when it is sent back to the board? Yes, you may. Yes, so it shouldn't be denied. You should be getting an SSOC. So that's an important distinction. So once you get a rating decision outside of the legacy system, let's say you get a remand, or you get a grant and a remand, or you get a remand. It goes down to the regional office and it's denied again. You should be getting an SSOC, which will allow it to go back to the board. And with that SSOC, you can submit additional evidence and arguments. You have a smaller window in order to respond. However, if you are remanded and you get a grant or a partial grant, that grant that is on a rating decision is now an AMA. And you'd have to file another appeal to it. If it's denied, like I said, SOC, yes, you may. If it's a decision, a rating decision, that is now an AMA.
If I could add something to that, just remember in the legacy, and really important point Ursula brought up about, if while in legacy you get a grant of something, that grant's going to be an AMA. But if you're fighting for service connection for any disability, the whole time in legacy, you can submit new evidence all the way up to the point that the board makes a decision. You can do it before the SSOC, after the SSOC, after the 30 days grace period following the SSOC. As long as the board has not made a decision, you can submit more evidence. So now keep in mind, in legacy, one reason we like legacy is because when it goes back to the board, if it goes back to the board, it keeps the same docket number as you had before. So once that 30 days is passed and once the regional office certifies it back to the board, you're going to get a faster board decision. So if you have evidence to submit, don't wait 6 months after the SSOC, because once the board issues a final decision on that, then you're out. Then you can't submit it. So just keep that in mind.
Those decisions, I know on our team, they're coming pretty quick after an SSOC. We've gotten the SSOC. We gather whatever evidence we have. At that point, we're getting that docketing letter saying, hey, it's back up here. You've got 30 days. And then if we send in a letter saying we've submitted everything, go ahead and make a decision, they're coming pretty quick with legacy. So definitely don't sit on it. Don't sit on it. We got another Alan Hurd. Has a case or claim that Hill and Ponton is working for me now? Or you have a case, okay. Is it recommended that I not file for any other claims during this time? I have an intent to file from October, and I would like to add mental health issues. So my advice with that is get with the attorney that you're working with and find out from them what their recommendation is. Even if you had another attorney, I wouldn't want to answer on that because I don't know your case or what's important or what they're going for and whether filing for anything might jeopardize something else. And so there's a lot of things that, you know, we're always looking at, and I would definitely get with your representative and talk to them about that.
Yeah, and if I may add, you know, I just speaking for ourselves, for myself maybe, if we're the ones working on the case, we much prefer that you not be out there filing your own claims. Okay, it doesn't mean we can't file them. It just means we would rather do it so that we know what's pending in the system. We know what to track. You know, we get a decision that somebody else filed. We didn't realize it was filed. It takes time to figure out why we have the decision, where it came from. Is it right or wrong? You know, and lots of times, more often than not, something goes wrong with it because of how it was filed. So I am not one of those representatives that will tell you, don't ever file a claim while one's pending or mess your claim. You know, it won't do that necessarily. We file claims all the time while we have other issues pending. But we would just prefer to do it rather than our clients be out there doing it on their own. And we may sometimes tell you straight up, don't file the claim. We have a very good reason for doing that. If you file it then we may have to think about what we're doing. So just keep that in mind. You know, nobody can stop you. At the end of the day, it's your claim. Just giving you my 2 cents. You can always file a claim regardless of what your representative says. But at the same time, if you're going to have one that you trust, then just take their advice and go through them if at all possible.
Gabriella, I'm 100% TP, so I'm guessing total permanent for PTSD. I have an appeal with higher level review for SMC. What are the odds that my appeal will be overturned? 2 VA examiners filled out documents stating I need help with daily activities as well. I'm not entirely sure what you mean by overturned. I'm assuming, and just assuming, that when you filed for the SMC, it was aid and attendance because you talk about daily living, and it was denied, and that's why you're going higher level review. It depends on the evidence that's in the file. So aid and attendance is the need for the aid and attendance from someone else, and it's typically based on your ADLs, taking a shower, getting dressed, tying your shoes, things like that. If those are the types of things that you have issues with, I see those grants a lot more than I do with grants for things like PTSD, where you may have some issues with remembering things or taking your medications, or kind of more the help of someone to keep you safe within your society and safe within your home. So I know I don't have an answer to that question specifically. If there's evidence that you need help with your daily activities, and it's not daily activities, it's your activities of daily living, which are your basic needs of food, shelter, dressing, things like that. So it just depends. Kerry?
Yeah, if I could add something to this, same thing I say, I think, on every video. And it's not specific to this case because I don't know the facts of this case. But we'll take some bits and pieces out of this case. So let's say you're 100% for a mental health condition. And let's just say, for argument's sake, that is the only thing you're service connected for. You're going for SMC. Now, if you're going for SMC and you have one disability, this case, the mental health, the only SMC you're going to get 99.99% of the time is aid and attendance. You're not going to get housebound. I don't think I've ever seen a housebound rating being granted on a factual basis, because the mental health condition is simply not going to limit you to your home. Now, it could cause the need for aid and attendance, though. But take it with a grain of salt. You're rated 100%. Okay. The mental health condition is not going to cause you to, at least in by far most situations, not going to cause you to need help dressing yourself or feeding yourself or going to the bathroom by yourself. Okay. We're talking mental health, not physical health. It may, under the most severe circumstances, prevent you from keeping yourself safe in your environment. And that can mean a lot of things, but it doesn't mean needing a reminder to take medicine. Okay, I'm just, again, using that as an example. So if that's your only residual to support SMC for aid and attendance, I don't know that I would file for aid and attendance based on the mental health. You just need one wrong examiner to get a proposal to reduce, especially when you're 100% and you come in and file a higher rating based on SMC for that same condition. So just take it with a grain of salt. Be careful. Don't put your 100% at risk. Now, if you are so far gone from a mental health standpoint that you are a danger to yourself if left alone, or a danger to others, then that's something to think about. You might have a decent SMC case there. But that's, when you're looking at aid and attendance, you've got the physical issues, and then there's a little semicolon in the regulation, and it goes into or the inability to keep oneself safe. And I'm not quoting it. I'd have to look up the regs to get the verbatim language, but that basically means you're a danger to yourself if left alone. And just, be careful. That's all I've got to say on that.
Yeah. And as you were talking, it reminded me of something which I think is also just good when it comes to the SMCs for housebound and aid and attendance. If you are 100% for a mental health condition and you need help with those daily living because of a non-service connected disability, like you blew out your back or something else, the aid and attendance isn't going to be based on those conditions. So they're going to look specifically at the service connected conditions and whether you need aid and attendance. There is another program which is done through VHA, which if you haven't looked into it, you may want to, and that is the caregiver program. So that is also something where you need the help of someone who is a caregiver who lives in your home, and then they help take care of you because you need help with these things like remembering to take your medication, keeping you safe out there. I haven't seen they're not very giving with the program, meaning it's difficult to get those benefits, but it is something, and you only need to have a 70% rating. And if your PTSD is at 100%, but let's say a non-service connected condition like Parkinson's is having you need to have the aid and attendance, you can still qualify through that program. So there is that. So moving on. Old soldier, can you discuss claims that are raised by the record? Specifically, when VA knows there's an issue like unemployability but fails to act on it or find out more details to start a claim like TDIU. I'm going to let you take this because I have someone knocking at my door and ringing my doorbell like 17 times. So I just got to step off for a second. Sorry about this. I'll be right back.
All right, I'm going to read the question again. Can you discuss claims that are raised by the records, specifically when VA knows there is an issue like employability but fails to act on it or find out more details and start a claim like TDIU? Okay. The thing we see the most that is potentially raised by the record are just that, claims for TDIU. And how a good example of that would be, say they rate you for a mental health condition. It doesn't matter what the condition is. Let's say it's mental health at 70%. Then at that point, let's say there's evidence in the record that shows you're unemployable. Okay. And then let's say beyond that, there's evidence in the record that shows that unemployability might be due to the mental health condition. Okay. So now you kind of got everything sort of lined up the way it should. If VA is doing really everything they should infer a claim for TDIU. That doesn't mean it's going to be granted on that rating decision. They may have to send you an application, something like that. But now, and then give you a chance to file it, and then it could potentially be tied to that same claim at that point. But if there's nothing in the file that indicates whether you're employed or not, or let's just say there's something in the file indicating you're unemployed, but nothing in the file indicating that it's due to a service-connected condition. VA is not bound by law to raise the issue of unemployability. And one thing that they are told not to do, and I agree with this one, is not to raise TDIU just to deny it. Okay, if it's not expressly claimed, it should be raised when there's a chance it might be granted, when those things line up. Your evidence of unemployability and evidence that unemployability is due to a service-connected condition. Now, whether they're going to grant or not, in that scenario, it's arguable that it's raised all the time. But if you don't have that stuff, they're not supposed to infer it just to deny it. Now, every once in a while, when they consider it, you won't know it because they'll put it on the code sheet, which they don't send out as part of the rating decision. And they'll have a little box on the bottom that says TDIU considered, but not found, meaning they didn't find enough evidence to warrant a grant of TDIU. And it'll say, therefore, not raised or something. And they're just saying there that, yeah, we considered it, we would have denied it, so therefore we didn't raise it as an actual issue in the decision. Now, none of that, big thing here is, none of that prevents you from coming back after a decision that puts you in the range for TDIU and filing for it. But a lot of people try to go back and say, well, 20 years ago, this rating decision here, it granted this, and I wasn't working, and you should have raised TDIU. Sometimes that's true. Sometimes it's not. So it's just it's a case-by-case scenario. And that's about all I can probably say about that. So case-by-case scenario, but yes, there are times when they should address it, and there are times when they should not address it.
That's exactly right. I was listening that whole time, and I am going to add just something real quick. When you're talking about the reason to be raised by the record, you see it in CMP exams, but if let's say, in 2020, you file a statement and you specifically say in that statement, I have PTSD and now I can't work, that's raised by the record. You have said because of your PTSD, you can't work, and VA is supposed to adjudicate the PTSD at that point. Now we have rules with AMA where everything needs to be on a form, and what they should have done at that point is sent out to you and say, hey, you're saying you can't work. We need to develop for that. And if they don't develop for that, there's an error there. So these can get quite complicated and procedurally hard, especially if later down the line you were denied for TDIU, even if it was raised back in 2020. So they're harder, definitely. All right, another step, part 1 of 2. Regarding rating changes for some disabilities in May 24, I'm already rated for one of these disabilities. My symptoms have not changed, but I would be rated higher under the new ruling. How do I request file for a rating change? Will the VA use my existing DVQ and other evidence all dated 2023, or do I have to submit these documents? I do know the rule is they have to rate you whatever's more favorable. I will be 100% honest with you. I don't know how you get VA to change your rating to the more favorable regulation without filing for it. Usually it's the other way around. Normally, we're trying to keep veterans in the more favorable previous rating. So I don't know, Kerry, how do you do that?
Well, I mean, essentially you file a new claim. If you haven't had a claim pending and what you're rated in the rules and regulations for what you're rated for change, and you look at them and you think you qualify for an increased rating based on the change, Ursula's right. They're not going to do that for you. You got to file a request for an increased rating. In today's world, that would be on a 526. You know, I disagree with that, but that's the way it is. And they would bring you in for an exam like any other claim, and they would rate the condition then under the new criteria. And keep in mind, because your claim starts in that scenario after the new criteria went into effect, and you don't have a pending claim that crosses both. You know, in other words, it wasn't pending when the law changed, right? You're going to get rated based on the new criteria and only the new criteria. So just keep that in mind. So if you're going to do that, make sure, which there's nothing wrong with doing that. Absolutely nothing wrong with it. But just make sure that the new criteria are actually more advantageous to you, or that your condition has actually, gotten worse. So, and that's really as complicated as it needs to get. File a claim for an increase.
Christopher Goldsberry, how long are appeals taking at the VA? I'm guessing that's the board at the BVA. Oh, a long time.
Ones that are not advanced on the docket, meaning they're not expedited due to some form of hardship or age, I'm seeing in the faster lanes, and that would be the direct review lane or the evidence submission lane, about 3.5 years right now, which is incredibly too slow. But unfortunately, that's the name of the game that we're playing in right now. And now, if you're 75 or more, or if you have a hardship, a legitimate hardship that you can show, then the board is pretty fast in comparison. And so, we have to take a lot of issues to the board, and they can't all be expedited. But when we do have grounds to get them expedited, we try to do so. If the veteran or the claimant is 75 years or older, the board will do that themselves. Right? We don't have to file a motion for advancement any longer. At least,
but we do anyways.
We
are.
Yeah, we sometimes do anyway. But I've seen most of those here lately get advanced on the board's own discretion there before we do something, or about the same time. So just keep that in mind. 3.5 years if it's not advanced. Now that could change tomorrow. That's about the ones that we're seeing that are not advanced right now. And I could not have answered this question 6 months ago because we weren't seeing them. We literally filed appeals right after the new law went into effect, and they still had not been decided. So we didn't know how long it was taking. But the ones now I've seen actually get decided with no advancement. They've been pending for about 3.5 years. Now, if we file a new one today that it's not going to get advanced, does that mean it's going to be 3.5 years from now? We don't know that. We have no idea. It could be longer. The board could have, gotten its act together, and it could be faster. When we filed all of these that are now taking 3.5 years, the VA said at the time we filed was about 8 to 10 months. So if you go on VA's website, just one more thing for good of the order, if you go on VA's website, the board's website, I should say, and find their average days to complete a claim at the board and appeal at the board, those numbers are diluted with the cases that are advanced on the docket. And if board, if you're listening, yes, we know you're screwing the numbers like that. And I hope you're listening, but I'm sure you're not. But yeah, go ahead.
Okay, sorry. And just to add to that, also when we all started with the new appeals, VA is very much focusing on getting the legacy appeals out now. And so I think there's a big chunk of the BVA judges that are only working on legacy. So once legacy is taken care of, I think it's going to open up for some more judges to kind of handle these things. But like Kerry said, 3.5 years at minimum. I think we recently got one, Kerry, the other day that was 4 years. And we're sending out letters like, we filed this appeal 3 years ago, do something with it. They're just not. And, you know, and what another thing that kind of makes it take so long is, you know, some of the board decisions they're not good. And so we're having to appeal them to the court. And when they go up to the court and then they come back down, the board then has to work on those ones first. And so, you know, it's this whole combination of dealing with the legacy appeals, advancement of the dockets, things coming back down from the courts, which we are getting remands on everything we're sending up. And so they're kind of just like running around in this pile of things over here and aren't able to take care of the appeals that are in line and have been waiting in line. Hopefully they can get their act together. And then once they, you know, come up with a system, we can actually like get people moving through. Hopefully it'll start going faster.
Yeah, and if I could add one more thing, and I'm just kind of venting here, and this is probably not the video for that. Ursula and I have
we have venting videos.
We have an idea of a venting video. We haven't got too far with it. You know, I usually say the board on par gives better decisions than the regional office, and they do. Okay, they absolutely do. So, board, if you're listening, good job on the good decisions. But you know, we know when the RO top sheets a case, meaning they flip the first couple of pages and they don't go any further to make a decision when all the important stuff is further. Okay, it's so apparent when that happens in most cases. It is a sad day when we see it done by the board. Because we depend on the Board of Veterans Appeals. They have lawyers looking at these cases, writing the decisions up, judges signing off on the decisions. They have an army of people, right? You should never get a case that's top sheeted from the board. And I raised that for a specific purpose. Got one yesterday. One of the issues was the propriety of a reduction in the veteran's GI condition from 30% down to 0%. That was the issue before the board. The RO had reduced it from 30 to 0. So anytime you have an appeal like that, the issue is not an increased rating. The issue is the propriety of the reduction. Different rules for each one of those apply, okay? The board listed the issue as an increased rating, said the veteran was at 30% and remanded it for the RO to consider a rating higher than 30%. That was not the issue before the board, right? The veteran was not rated at 30%. The veteran was 0%. The board top sheeted it. They would have just looked a little further. We submit arguments. Read our argument, you'd know what the hell is going on in the case. So yeah, I'm venting a little bit, but that's frustrating when a case sits there for a long time and then of all places, the Board of Veterans Appeals top sheets a case. So if I can get on a soapbox and say, do your job better, that's me doing it. So anyway, I'll pass to Ursula now. I feel better.
Yep. And then just to finish that up, what really sucks with that is, once you get that remand, you go down, you get a decision that you then need to appeal again, and you go to the back of the line at the board, and you got to wait another 3.5 years. Not to ruin your Wednesday, but it's frustrating for us as representatives and advocates as well. But so Christopher, like I said in the first thing that came out of my mouth, it's a long time. It's taking a long time for VA appeals.
Yeah. So well done, VA. Congratulations.
Great. Oh, how long are higher? These are doing better. Sorry.
Not as long.
Okay, so let me get this back in so I can hear. Hold on. So they're not taking as long. I'm telling my clients, I would say low end is, 4 to 6 months. You're lucky if you get something in 4 months. More like 6 months, but anything after that, I start getting a little antsy and start being like, what's going on? Why is this taking so long? And I'm checking to make sure that everything is established. They're working on it. It's, it's somewhere. So those are definitely much, much quicker. I'd say 6 months minimum, 4 to 6 months minimum, a year max.
Well, and I think they fluctuate. 6 months ago, we were getting some very quickly within a couple of months. Now we're getting some, like Ursula said, 4 to 6 months. And I suspect it'll go back to closer to 2 to 4 months at some point. The ROs and the people that control all those have a little bit more leeway on how they spread out the cases. Since the AMA, they've done a fairly good job of keeping most of them at the 6 month range or below. That does not apply to everyone. If you are a widow and you have a death benefit claim, a plan to take longer, again, well done, VA, on the widow's claims. For some reason, they just take longer. They're centralized at a certain location, and they've got more of a backlog, and the widow's cases are going to take longer. The other category are VA employees. If you're a VA employee and your case is done at the RAC, or you have some other reason that your case is at the RAC, your brother's a director, something like that. The RAC is where the employees' files go to get decided. It's in St. Paul. Those take longer because they're the only station that does those types of claims. We've got both, and anytime we see one at those locations, we know it's going to take a little longer, but still well under a year usually, or at least within a year. Fortunately, not as slow as the board.
Yeah, and that's why a lot of times, like after a supplemental claim, I know I will typically try to take a higher level review and see if I can get it resolved there, just for the timing. But if it's an issue that I just know VA isn't going to do at the regional office, sometimes you just have to go wait at the board. All right, we got time for one more, I think. So pick a good one, Nate. Is that a Menmeng 8030? When I first started filing for VA disability claims, I had no idea what I was doing, so I filed for what I thought was in my medical records. I got denied for plantar fasciitis, but the examiner diagnosed me with plantar fasciitis. On my medical records, I had foot pain in both feet and was even put on a running shoe only profile. I was service connected at 10% for right foot. I'm not even going to try to say that. When I broke my foot, but what should I be doing while I gather more evidence for my supplemental claim? I think read the decision and find out why they denied it. If you had a profile for the plantar fasciitis, it could be one of those things that was noted on your entrance exam. And so they're saying that, well, you had it before, So, you know, really reading the rating decisions on why they denied, sometimes they can be very helpful. But I think, yeah, Kerry, you go ahead.
Well, on ones like that, what I've seen a lot is the examiner, when VA calls you in for the exam, he looks at everything and goes, you don't have plantar fasciitis, you have metatarsalgia. You know, I don't know if that's what happened in this case, obviously, but I see that a lot. You know, it could be vice versa. And in that situation, VA is going to deny service connection for plantar fasciitis, and they're going to grant service connection for the metatarsalgia. And the metatarsalgia could have been where the foot pain was coming from. Doesn't mean the examiner got it right, but that could easily explain a scenario that you stated there.
All right. Well, that was the last one. So thank you guys so much. And one of us here at the firm, well, two of us